Good morning, Bill Sieglein with the CSO Breakfast Club. We're in New York, the New York offices of Reed Smith, one of our hosts here, and I'm with Paul Bond, one of the lead attorneys out of their Princeton office. We were talking about third-party vendor risk management today, and Paul did an introduction for us, but one of the things we wanted Paul to address is the new Supreme Court case that has to do with texting. You may have heard that there's a gentleman from California who was on the SWAT team who was issued a pager that had texting capability. He used that during sometimes personal hours. They used some techniques to review some of his text messages. He's claiming that it was a violation of his privacy. It's a very important Supreme Court ruling that may impact our members. So Paul, if you could just address a little bit about that case and what could be the ramifications for chief security officers and their programs as their companies are issuing maybe cell phones or PDAs to their individual employees.
Sure. Well, as you indicated, Bill, the issue is this gentleman was employed by the city of Ontario, given a pager to use in connection with his work as a SWAT team member. He went over his character limits over and over to the extent that it prompted his superiors to review what he was doing. It was found that he was sending sexually suggestive messages and other inappropriate communications to his wife, to his girlfriend, and to a fellow trooper, all of whom are also plaintiffs in this suit.
Interesting.
Yeah. And he was terminated. He and all of those individuals sued the city for violation of their constitutional rights to privacy, since the city of Ontario is a public entity. The issue before the Supreme Court is twofold. One, did he have a reasonable expectation of privacy? Did any of these plaintiffs have a reasonable expectation of privacy in their communications?
And that's, I guess, because it was a piece of equipment issued by the employer.
Right. And secondly, whether, if there was a reasonable expectation of privacy, whether the actions of the government went over the line. As to the reasonable expectation of privacy, the interesting thing is, when this individual, Mr. Kwan, started as a trooper, he was given a written policy by his employer.
Right.
And the policy said, you have no expectation of privacy in your emails or your other communications. Didn't specifically say in your text messages. It said that you shall not use city resources for personal use. You shall not make inappropriate communications. And that we can monitor you at any time. He was not only given this policy, he signed it.
Which is express consent. Right?
Express consent to the policy. Nevertheless, he claims he still has a reasonable expectation of privacy. And the reason for that is, he says that he was told by his superior when the issue of overage on the texting came up, listen guys, as long as you pay for the overage, I'm not going to audit what you do.
So the superior sort of changed the policy on the fly, potentially, which could be, and you use the term, a fly in the ointment here, so this could be a problem.
Well, exactly, and this is the portion of the opinion that could have the most ramifications for employers in the private sector. Some of the issues before the court are constitutional and don't necessarily impact private employers, but for private employers, it will frequently be the case that you will have a written policy which sets forth certain unambiguous, no privacy expectation rules and rules about the use of company technology, but you might have someone at the computer help desk or someone in IT support or an immediate supervisor who will informally give assurances that really we don't care that much about what you do, as long as you're still getting the work done.
Interesting. So I guess the court can rule either way here. I'm surprised it went all the way to the Supreme Court, but let's assume that they rule in favor of the plaintiff here.
Mm-hmm.
What's the impact to our members as chief security officers? Will they have to go back and rewrite policies? What are your thoughts on that?
Well, it'll be very interesting. It was a spirited oral argument. You can never tell what the justices are thinking just by their questions. Sometimes they ask questions because they think other members of the court might need to be filled in on something. But for example, the Chief Justice said, well, aren't these privacy policies really like when you sign something at a parking garage? Boilerplate policies that nobody reads and understands, we don't enforce. If that were the view, then employers would have to do a lot more in terms of showing that the policy was in plain language, regularly communicated, regularly understood. Maybe that they test the employees for comprehension of the policy, and recording all of those steps in compliance. That seemed to be a minority view among the justices, but that was one suggestion. Another suggestion was that if they find in favor of the plaintiffs, another suggestion was that there may need to be some restriction on the use of technology by employees.
Yeah.
In fact, that was one of the arguments by the city. Well, if you're going to tell us that our policies, our unambiguous, written, signed-off policies, are no good, maybe it's the case that we can't, allow people to have this technology, to take it home, to use it on off hours. What you'd basically be requiring us to do is to give employees two sets of force them to have two sets of communication devices.
One for personal, one for business. Here, you come in the morning, here's your cell phone, hand it back in before you go home for the day. So,
Yeah.
well, I think it's going to have some interesting ramifications. I know our members are anxiously watching to see what that will be. We certainly appreciate you sharing your thoughts with us on that, and thank you for hosting us here in New York.
Thank you, Bill.
So for the CSO Breakfast Club out of New York, we just want to say thanks, guys, for listening, and we'll see you again soon.